Number one, audiences really listen to you better when you can do something nice for them. Number two, audiences, jurors included, will not listen well when they are really thinking about how badly they have to go to the bathroom. And number three, they won't listen as hard or retain as much if they're dying to have a quick cigarette or a drink of water. So I'm going to start by giving you a 5-minute break. But don't make it any more than 5 or Daryl won't let me cage you in the courtroom. Go ahead. I think we have to first put ourselves, as much as we can, into the place of the jurors and think how and understand how they are thinking and feeling when they come into the courtroom and sit down and hear the first words out of the judge's mouth. So I want you to watch with me this very short video and see if that helps us to understand.
Different features, and it will involve a subject you know nothing of.
Sorry.
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it. And you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can take notes, remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on other important aspects of the course. Now, I won't be telling you what is important in this course, or what the rules are for the final exam, until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it. And I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions. And you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
Okay, so the jurors need our help. Who here has won a case recently or ever? Why did you win? Tell me your name. Jeff. Why did you win?
Good question.
Thanks.
I had a good case.
Nothing you did? Just that it was the facts and the law was so good for you? Okay, he's not delusional. We got that.
They believe my client was a better witness than their victim.
They believed the client. The client told the truth. The victim was lying. Or at least not based on reality. Who else? Tell me your name.
Me, Megan.
Megan, why did you win?
Because my client testified very well, and they couldn't prove exclusive knowledge on the part of my client to certain information that enabled a crime to occur.
Did your client understand and believe your client? This is an unusual group. It's rare that I get the answers that my client took the stand and
I was in counsel of record. It was a capital case.
oh, don't take it away from yourself. Go ahead.
The attorney did a better job of less qualifying the jury than the prosecutor did of qualifying the jury.
Okay, so you were able to, in jury selection, find the jurors who'd be willing to see the case, see the world their way. By the way, I'll say, somebody who works a lot in jury selection, it's really rare that that somebody has that assessment after a good verdict. I find that going into a case, which we're all scared about, this is what I get. Denise, it's all about the jury. I mean, it's those 12 people. When the jury's in the box, we've either won or lost. That's all it's about. And then after the verdict, if by some miracle we've gotten an acquittal or a life sentence, if it's the case we're worried about that, you know what it is then? Is it the jury selection? No. It's the closing, right? Yeah, I did it in closing. I'll tell you what I think happens when we win cases, Matt. Every time we win a case, I think it's because we've allowed the jurors to see the world, or the world in our case, with our vision. Look at it like I look at it. Would you please do that? I think that we've reached beyond the jurors' minds. I'm not saying we've bypassed them, that we're asking them to stop thinking, but we've reached further than that. We didn't stop there. And we touched their hearts. That's where people make decisions most of the time. And I think that we have shown the jurors that voting not guilty is just the right thing to do in our particular case. It's not because they couldn't prove beyond a reasonable doubt versus technicality in the law that it's because it's just the right thing to do, damn it. That's why you should vote not guilty. So, let's talk about how we might do that. Lori has done a great job of talking with you about how to develop your theory of the case. And we're going to be working on that for 2 weeks. It'll get hopefully hatched today, and we'll continue to refine as we go along with each cross, with each direct, with each opening, with each closing. I want to talk to you about how we can effectively communicate that theory, that story, those things. Communication, I think we think of sometimes as a frill or as an add-on. If I get my jury charges in on time, then I might think about what I might do in my opening and what gestures I might use, or what demonstrative evidence I might use, or how I might talk to the jury, or come up with a story or a good parable or an alliteration, or I'll do that after I've done everything else. And we think of that as communication. It's that, but it's more than that. It's everything you do and everything you don't do. It's how you look at jurors. It's how you relate to your client. It's how you relate to the court and the court reporter. It is everything you do. You can't not communicate. You can only do it well or do it poorly. I have a little working definition of communication, which is up here before me. Communication is connecting. Connecting with the jurors, connecting yourself to your case. It's hearing and understanding, and it's being heard and being understood with trust, a word you don't always hear connected with lawyers, with empathy that comes from us so the jurors know we model it, as Lori talks to them about, and with interest. They rarely listen to the boring case, the hardest, so that's all up to us. I'm going to talk with you guys a bit this morning about jury communications as well as client communications, because they're quite interrelated, and the same tools and the same techniques will help with both. The tools that I want to talk about are really not so much tricks for you to use in the courtroom or with your client. They are ways in which I hope you can connect to your case, and you can get your head and your heart in the right place. Am I making anybody nervous using that kind of language, getting your heart in the right place? Usually lawyers kind of, sphincter tenses just a little bit, like, oh no, I'm gonna use my heart. I'm gonna feel something. I'm sorry, you're gonna be hearing that. Because when your head and your heart are in the right place, then you know what, the right words come out of your mouth, and you just do the right thing with your body. You make the right gestures. Your voice does the right thing. That's a whole lot easier than trying to put it on like a suit. So we're going to work on that. Once you have that, once you have those tools so that you've made connections with your case, then we'll talk about some techniques that we can use in the courtroom that help us all, that make it more interesting. I want to talk to you first about the challenge that we have. We are a challenged group of people because we are lawyers. I don't know if you know, but people actually make jokes about us. What do you call 10,000 lawyers at the bottom of the ocean?
A good start.
A good start. That's exactly right. Don't people love to tell you this? Yeah. Sometimes jurors do. That's really nice, too. We always have to laugh, right? Well, it is just kind of, we're an easy target, but it's also something very real that we all face when we walk into the courtroom. Some people are thinking those kinds of things. One question I like to ask on juror questionnaires, we're in a case where we're granted one and we have some luxury with, questions beyond the facts or the issues in the case, are what's your opinion of prosecutors and what's your opinion of criminal defense lawyers? Because sometimes, maybe 50% or 70% of the people will say the same. Hard job, somebody's going to do it, must be smart, whatever it is they say, they'll say the same. But then there are those who say prosecutors are doing God's work, and I just want to give you all a clue or a hint from an expert that I've certainly turned to be. If I use the word scum in relation to a criminal defense lawyer, you want to try to excuse the juror. Here are some actual comments, though, that we've got from jurors on that question. What do you think of criminal defense lawyers? They are like greased weasels. This particular juror could not define greased weasel for us when we asked further what she meant by that. She did say, I didn't think you were going to read that. Okay. But she did tell us that Bill Clinton was one, just by way of example. Realistically, a lawyer's job is to prove his client innocence. So much about our illusion of the presumption. And he'll do anything he has to get him off, and I mean anything. They say they're there for justice, but they're there for themselves. They play to the cameras. This is one older man. We were doing individual sequester voir dire death penalty case, and so we got to call folks into judges' chambers to follow up on some of their questions. And he put something down like scum or something that we needed to follow up on. And he did not want to talk about it. And the judge had to tell him, got to order you to explain your answer because everybody here has a right to know. And he really wasn't very educated. I don't think he graduated from high school. And so you might think he wasn't very articulate. But he finally turned red in the face and said, okay, I'll tell you like it is. You make your living off your fellow brother. You sit there and you just wait for him to stumble. And then you say to him, I'm going to help you. But what you do is, you suck the life plumb out of him. And then he takes this pregnant pause and looks us all in the eye around the table and says, and I'll tell you something else. I don't care much for insurance salesmen either. Well, in the opinion polls, we are sometimes neck and neck with insurance or used car salesmen. Sometimes one ahead, sometimes one below. We do slip a bit. And what's happened? What's happened since the days of Atticus Finch, where everybody wanted to grow up to be like him? What's happened since there was a weekly show on called Perry Mason, where the defendant was wrongly accused every single week? And the prosecutors and the cops were trying to hide the truth. What's happening? Well, we have this stereotype that exists now, and it has for a while. But I'm not here to be discouraging and to say that we have to be handicapped by it. We go into the courtroom, I think probably most of the time, one down from the person, the lawyer on the other side of the courtroom. But the good news is if we go against that stereotype, if we present a person who they are not expecting, then we have a chance not to even just be even, but to be one up. And if you could, the thing that makes that very real for me is I just cannot stand to be bothered by salespeople. I've got just a thing about it. I want to get in, shop, get my things, and get out. And I know every time I go in a store, I'm waiting for them to hit on me, to follow me, and I generally tend to be pretty polite to people, not salespeople. I walk in, they say hello, I say, leave me alone. You know, I mean, not quite that bad, but close. And I am just waiting for them to come follow me. If I ever have one that says, I understand, just let me know if you need anything, and he or she doesn't come after me, then I start thinking, I wonder what's wrong with them. You know, and then I might even just ask a question to see if they'll then descend on me, you know, and take that opportunity. And if they don't, if they really just answer the question and go back to what they're doing, by the time I'm at the cash register, not only have I bought the store out, I'm like inviting them over for tea. You know, you have any kids that can play with my kids? I mean, I love this person now because you didn't do what my worst fear was, and you did what I really like. And so we have that same opportunity. The only way for us to do that is to show the jurors who we are. I don't mean the lawyer that you are. I mean the person that you are. The person that you are when you got out of bed that morning and brushed your teeth. The person that you are when you go home at night and coach your kid's softball team or play rugby or bake brownies or grow tomatoes or whatever it is that you do. That's the person that we need to show the jurors. I'm going to show a quote, see if anyone knows who said this. We believe good men more fully and readily than others. That is true generally, whatever the question is, and absolutely true where exact certainty is impossible and opinions are divided. It's not true, as some writers assume, that personal goodness revealed by the speaker contributes nothing to his power of persuasion. On the contrary, his character may be called the most effective means of persuasion he possesses. Anybody got a guess? Or anybody know? Sorry? Bush, did somebody say? Does Lori want to speak to that? Aristotle. Aristotle in 350 BC. I generally kind of try not to talk about dead Greeks this early in the lecture because I feel like, you know, I'll give myself away that I was Latin Club president, not homecoming queen in high school. But I think it bears talking about. Aristotle, if you remember, talked about the three important parts of persuasion: ethos, logos, pathos. Ethos is the character, the credibility of the speaker. Logos is the logic of the argument. Pathos is the emotion that we bring forth in the people hearing our talk. As attorneys, I think we spend a whole lot of time on the logos, on the logic of the argument. After you come to a few seminars like NCDC, we start to spend more time on the pathos, the emotion that we bring forth from the audience. Very little talk about the ethos, the character of who you are. And that's what Aristotle said is the most important part of persuasion. Now, a gajillion research dollars and many, many centuries later, social scientists have proved he's right. We are more easily persuaded by speakers whom we find of good character, trustworthy, credible. It's not rocket science, I guess. We are less easily persuaded by speakers who have a vested interest in the outcome. That's us in the car salesman again. The good news. If we like them, we don't care. If we like the person talking to us, trying to persuade us, we don't care if they have a vested interest in the outside of the outcome or not. like somebody? Why do you like them?
I think because we like them because we feel that they're interested in you, they like you, they connect with you, they understand you, they're not trying to intimidate you, they love you.
He said just about everything I was going to say in the next 6 pages. Because they like you is very big. We like people who like us. Because they listen to you. Because we find them important. Anybody else?
Genuine.
Who are genuine. Exactly right. We like people who are themselves, who aren't trying to be somebody that they're not. Now, how do we accomplish this in the courtroom, for heaven's sake? How do we show jurors that we like them? And if anybody ever doubts for a moment how important it is to people to actually just be liked, do you just think back with me to, gosh, it's been, I don't know, 10, 15 years, when Sally Field won her second Academy Award for, I think it was Places in the Heart, the movie where the river comes in and got to take part, but they say that she'd already won one for Norma Ray. Okay, now, I don't know that there's any other actress, maybe one, in motion picture history who's won 2 Academy Awards, Best Actress in a Motion Picture. And she's not thinking, wow, I've made history. She's not thinking, boy, now I can charge $30 million for my next picture. She's not thinking, boy, that guy who, whoever it was who dumped me last, I hope he's watching now. What does she say when she gets up there? This means you like me. You really, really like me. Who would have thought after Gidget and the Flying Nun, don't embarrass herself anymore. But in front of all of America and a lot of the world, this is what she's saying when she won this Academy Award. Her peers like her. That's what it meant to her. How do we show the jurors that we like them?
I think that honesty is the most important thing.
By being real. We're really kind of dissing people if we're not real with them, aren't we?
We respect their opinion.
Exactly. When we respect their opinions, or at least show that we acknowledge them, right? A lot of times in voir dire, and that's another lecture, I'm not going to do it now, but we, I think, tend to think that we are looking for the right answer, and we let jurors know when their answer is wrong. And we really want to know what they have to say. And you may not agree with it, but by golly, it's your opinion, and I'm glad you told me, because now I know something about you. I think that's very important. We can show by active listening techniques. That means that we listen to the words that they use and use them back. This works for clients as well. That we start talking in the language that we hear them talk to. This means that we follow up with another question. So many times we think we need to ask, have you had the experience? Well, what about asking something besides just have you had it? Like how'd you do with it? Or what? By that kind of thing. We also like people who are like us or with whom we can identify. And this is a lot of what I'm talking about when I say come to the jurors from the place, not as a lawyer, because I've got to tell you something. Who do you think the jurors identify with most in that courtroom? And I'll give you a hint. It's not your client. Second hint, it's probably not you. If you think about all the people in the courtroom, who do you think they probably identify with the most?
The court reporter.
The court reporter, the bailiff, the court clerk, the staff. I think that's probably right. I think most of the jurors identify more with the court staff than they do us, the judge, or anybody else there. It's the way you deal with those people. A lot of the witnesses that you cross-examine, the jurors relate to. A lot more than they do witnesses that you direct sometimes. It's the way we deal with them. Like Lori said, it's a snitch. Of course you're not going to say, how are you doing this morning? But that doesn't mean that everybody the prosecutor calls to the stand is your enemy, that you don't want to have anything to do with, that you speak with and discuss, that must be lying. I worked on a case where the victim, there was a woman who was murdered. We, of course, contended that her husband is not the one who did it. She was decapitated, and they found her body but never her head. And they called, this is the mother who came to take the stand. she had done nothing to cause any of this to happen. She was just there for the obvious reason, to, bring sympathy and feeling part of the jurors. So what was the only way that after she could barely get through her direct, the only thing the lawyers that I was working with could possibly do to show the jurors I'm feeling like you are right now is to say, I'm so sorry, we have no questions. You have got to, in a situation like that, know how the jurors feeling and show them that you feel like they do too. And you feel for this woman. It doesn't make you want guilty. So let yourself, as you're going through this next couple of weeks and the rest of your practice, think hard about the emotion that you need to have, that you hopefully do have, with each of the witnesses that you talk to, that the jury will have. And if you can be congruent with them, be congruent with them. If you need to bring them around to your way of feeling, then you do that. But if they're feeling one way and you're demonstrating another, chances are we're going to have a disconnect. We're going to have a turn. What role in your life would have the most appeal to a juror? Now, we can't, obviously just, oh, your son plays baseball, I love baseball. We'll get calmed down for that. But we can just have that mindset when we're talking to them. What do you think makes us the most unlike jurors? What makes them, do you think, look at us and say, I can't relate to that person? What's our biggest stumbling block, the thing that gets in the way the most of us effectively communicating with jurors?
Words.
The legalese.
Thank you. Are you guys just helping me out here this morning? Exactly. It's the language is our biggest barrier. It's the lawyer words. It's the words that we felt so darn good about ourselves when we said in law school. And it's not only just the legal language. For some reason, we start talking goofy when we start doing cases. I guarantee you, not one of your jurors drove to the courthouse and exited their vehicle that morning. Why do we talk like that? They drove down there, looked for a parking place, were worried they were getting late, pulled in where they shouldn't have, and got out of the truck. That's what they did. At what time did you arrive at your destination and exit the vehicle? Don't talk like that. Even when you're doing direct or cross, talk like you talk, and people will listen. Words have texture. Words have color. Words have power. I am desperately trying to teach my 4-year-old that right now. Your words have power. Use them carefully and choose them carefully. We need to do that. We need to start choosing the words in your brainstorming exercise this afternoon that we want the jurors to use in the jury room. We pick the words. They'll like them. We disconnect with jurors sometimes when we get into too big of a who's the biggest jerk contest with the prosecutor. Now, I completely agree with what Lori said. You can't come in and, do small talk and talk about the cocktail party or the home run at the ballpark last night and then get upstairs and say he's a, lying piece of, trash that's about to put on perjury. We don't do that. But we also can disagree with respect and dignity. And you know what? Judges will respect, not all judges, I know, but generally you get respect from the court and the court staff more when you do that, and that really shows to the jury. I was just telling Daryl a story about a case I worked on recently. It was a federal case, and they had sit down with big guys from D.C., from Justice, to try the case. And I don't know, some of you do federal work have had the pleasure, but they can't find a way to pay for bad in the courtroom, So it was just a pure delight to watch. And one of these prosecutors just irritated the judge to no end because he just couldn't direct a witness. He would ask leading questions. He would talk when they were talking. I mean, just basic stuff. He just couldn't do it. Now, the lawyer I was working with could have just kept, getting after him and saying, why can't you even do what, But he didn't. He just did the same objection, leading, witness, he just did it calmly, quietly, respectfully. And so the judge, because he wasn't saying it, started feeling the need to say it herself because she was getting that irritated. So she calls the lawyers up to sidebar after this had gone on, all morning, and asked the lawyer, I wish I could use the name I want, asked the prosecutor, could you please tell me, sir, and this is not, the jury's not hearing it, it's a sidebar. Could you please tell me, sir, what law school did you go to? You know it's going to be good, right? He says, Georgetown, Your Honor. And at Georgetown Law School, did they teach you about asking non-leading questions? Yes, ma'am. Did they also teach you you're not supposed to interrupt a witness? Yes, ma'am. Did anybody else in your life ever teach you that it's impolite to talk when other people are talking? My mom. Well, I want to tell you something, she says. I am very glad your law professors and your mother cannot see you right now because they would be very disappointed. Now, when we walk back to the courtroom, sucking in your cheek so you're not laughing, he's red-faced and like this. The jurors didn't know what was said, but you know what? They got the point. They knew who won and who lost up there, right? So I'm just making the point that when you don't go as far as you think you can go sometimes with your opponent, it's beautiful when somebody else does it for you. Okay. If we do all this, we accomplish all this, we gain the jurors' trust, their credibility, they like us. And I'm not talking about being Eddie Haskell, so please don't hear me say that. I'm just pointing out that it really is better for you if they like you. Then they will be willing to look through our eyes. They'll trust us enough to see if they can see the world, if they can see the case with our vision. And let's talk just briefly about touching their hearts. Another Aristotle book, I think. Have a reason follows emotion next. Reason follows emotion. It's the power over emotions that the life and soul of oratory is to be found. And once again, a gajillion years and $1 billion of research later, social scientists have found that this is in fact true. Robin Hogarth is a researches decision making at the University of Chicago from sort of a marketing perspective. And he's coined a phrase, post-decision logic, which means that most people make decisions first out of emotion. They make an emotional decision. And then after the decision's been made, they come up with a logical explanation for why that was the logical decision. The more important the decision, the more likely people are to do this. So it's our responsibility, our calling, to bring the audience around to the right state of feeling. And if you think that Madison Avenue advertising agencies aren't onto this, think again. When we're buying a car, think about the commercials that we see for whatever the SUV du jour is. We don't see the hood up and the engine running and the cylinder thing and the fuel shooting through whatever it shoots through. And, we don't see the sled test with the dummies not getting their heads blown off and all the reasons that we say we would buy a car, right? Safety, efficiency. We say that. What do we see? We see this beautiful SUV left to a house, parked nicely. We see the house painted probably yellow, lawns mowed, flowers fresh. The door pops open, who comes out? Yeah, 2 kids, clean, not fighting. Mom, picnic basket, dad, looking like, just is ready to go golf. But no, he's spending the day with the family instead. And then out bounds a dog, usually a golden retriever. Again, clean. Hasn't just eaten anything he shouldn't have. Fresh breath in the dog. He gets in the car, the whole family gets in the car, then it takes off. Then we hear some music, and suddenly, even though they've just pulled out of their driveway on Main Street, they're driving through a desert, right? And then the car usually ends on some peak at the front. That's the car commercial. We're not buying a car, we're buying an experience. We want to be like them. We want that to be our Saturday. I know I do. That's what they're doing. They know that our emotion is is what's going to make the decision. We've got to be aware of that when we try cases. Our clients are generally, at least for me, the best way to get my emotional batteries charged in the case. They are the best way to find what the emotion in the case is. And I don't care if it's a securities fraud case. It's got emotion to it. We've just got to find it. A lot of us feel like this, I think, sometimes when we go into meet with our clients. We're afraid we're going to be faced with this scenario. Oops, I'm wrong. And now here's Bob with the situation analysis. Thanks, Ed. Well, basically, we're dead meat on a stick. Don't you sometimes feel like that when you're going to go talk to the client? You're going to feel like, if I ask questions and he or she tells me what he tells me, I'm going to be dead meat when I come out of there. I would just rather not know. Let's do rethink. Clients are a great resource. They will explain things to you. Sometimes you think you may not want to know, but they'll explain more than the night question. They'll explain how we got there in the first place. Not by you asking them that question, but that's the kind of thing we can learn from them. They'll tell you about their life, which began way before the night in question, and usually, with most of our cases, answers the question of why we're here. Why are we in this mess to begin with? Sometimes they really were in Cleveland bowling, why it happened, but my experience is most of the time. I'm not saying we're guilty, but I'm saying they can help us understand why we're in the pickle that we're in. Who your client is essential to your theory of the case. Understanding their world is essential to your theory of the case. When you go, and tomorrow you're going to have an exercise where you practice client interview. You'll have an actor who will kind of play your client. That first client interview is not about control. I'm going to say that again. It is not about control. Let me say it one more time. It is not about control. Going in and thinking, I've got to get this guy or this woman under control from the get, or they're going to, it's not about that. Yes, you do, and yes, you will, but you got to give a little to get a little. So I'm hoping you can approach it that way. Sometimes when we go in, I think we think that we already know. We've read the police report. We know, a little bit of background information on them, perhaps. We've got it figured out. And this is one of my favorite philosophers. That's Aristotle Stephen Wright. Reminds us that a conclusion is the place where you got tired of thinking. I think sometimes we make conclusions about our clients before we ever meet them. And I just want to encourage you not to get tired of thinking before you go in that door. You need to, I'm just going to give you a little suggestions that I have for dealing with clients. For the first 5 minutes, at least, check your needs at the door. Forget about what you need. Find out what they need from you. I can feel you cranking already. If you have needs and they have needs, we've got to find a way to meet them both. Please hear their concerns as real concerns. Don't tell them something's not important. If it's important to them, then it's important. Whether or not it may be important to what you think your legal agenda is right now. Because if you don't know this already, we'll give you a little heads up. They're not going to stop talking about it. Just because you tell them it's not important. Neither will my 4-year-old. I'm learning a lot from parenting. Just tell them we'll deal with it later, or we'll deal with it when we can, or we'll deal with it, but we'll deal with it is what they need to hear. Make a promise that you can keep. It may not be a lot. I mean, it certainly can't be that you can answer their call every time they call. Probably not that you can come back tomorrow to see them. But find something you can promise and keep that promise. I found lifesavers work miracles. And if you're seeing clients in jail and you're not supposed to bring things like that in, please don't hear me advocating that you bring in contraband unless you feel like you can get away with it. But I generally just find out with clients, what lifesaver do you like best? Well, they're not expecting that question. Sometimes they know, and sometimes they don't. But you can push them if they don't. And so we know there's like fruit flavors, there's mint, there's, and they'll come up with what flavor lifesaver that they like. And then if you show up with it, the next time you see them, whether it's meeting them in court or jail or whatever, it makes an impression. It just does. I know that seems like a little thing, but it just does. Tegazinski's was butter rum, just in case you want to. Then you may be thinking, okay, lifesavers don't understand my clients, lady, I don't deal with those kinds of clients who would get into lifesavers. Some of you may know David Lewis, who's on faculty. I don't know if he's going to be here next week or not. He was representing some years ago General Noriega. Remember? A cream puff, right? Not a touchy-feely, soft guy. David found out that General Noriega liked Oreos. So he was able, at wherever he would interview General Noriega, to bring in Oreos. And he would put 2 on the table right beside him and ask the general a question. And if he didn't respond as very forthcoming as David needed him to be, he would just slide the Oreos slightly towards himself. Then he would come at it another angle, and if the general, was a little more forthcoming, he would take one of the Oreos and put it in front of him, and the general would eat the Oreo. So I told David, when he told me this technique, I can't imagine what it would take for you to have to go through the double stuff. Okay, so you need to save those until you really have the need. But it worked with him. So I'm just saying, it can work. Meg Gaines, who's also in faculty here, don't know if you guys have had the privilege of knowing Meg, but she did her LLM research on client satisfaction with their lawyers, criminal defendant satisfaction with their lawyers. And they were all doing a lot of time. So I'll just give you a hint that the people who were the most satisfied with their lawyers were not the ones who had gotten found not guilty or who had gotten light sentences. But do you know the kinds of things that they mentioned when they mentioned why they liked their lawyer? Anybody want to guess?
They picked up the phone and talked to me, or?
You got it. They listened, they picked up the phone and talked to me, they cared about my family, they found out if I got the medicine that I needed, if I wasn't getting a shower, they filed a motion so I got to take showers. It had nothing to do with their closing arguments, with winning the case, with the legal wrangling they did, with any of that stuff. It was just being human with them. And that likability that comes back again, it really makes us, if you want control, if you really want control, that's the way to get it. To get their likability, them to like you, trust you, respect you, that will go a long way. If you don't get it, you're going to be fighting your whole relationship, and it's going to show. Use their words again, like the jurors. Acknowledge experiential deficits. If you don't know how they feel because you weren't raised in the projects or you weren't raised on a yacht, whoever your client is, then don't act like you were. But just say, I haven't been in that situation. I wonder tell me something about it, what's it like? And the more they talk, the more you'll realize you may not have had the experience, but you've had the feeling, by God, I bet. All of us only have so many feelings. And we can find times that we've been dynamically in the same situation with our clients so that we'll have something to talk about. I want to give you a little challenge. Ask what you're curious about when you do your client interview. Try to ask 3 questions that have nothing to do whatsoever with their case. It's just about them. Just what are you curious about? over 10, I'm sure didn't weigh, 90 pounds. He was about 6 feet tall, pencil thin, pasty white skin, bright red hair, probably called Carrot Top in school. Kind of a computer geek guy that worked for U.S. Sprint. And he and his wife were separated, and he wanted to get back together. And he something set him up one day. And right in front of the little boy, killed her with his hands, put her in a garbage bag, didn't dismember her, thankfully, just put her in a garbage bag, put it in the back of the car, put the kid in the front of the car, drove around trying to decide what to do, realized that was really a bad idea, went home, took her out of the garbage bag, put her back on the floor, called 911, said, guess what I just did, and was in the driveway waiting for them when they got there. Not really a whodunit. They were seeking the death penalty, but we had, we're able later to resolve the case. But at any rate, I was visiting him in jail one day, and I just wondered, here's this kind of pencil-thin, tall, geeky, pasty white guy in jail, and I just couldn't see him shooting hoops with the guys. It was a county jail that much. So I asked him, Frank, what the heck do you do in here all day? Hardly a brilliant question. He said, I read. I said, what do you read? He said, not surprising, Stephen King. Stephen King scares me silly. I can't read Stephen King, but I had seen that movie Misery. Anybody remember that? Kathy Bates, James Caan. So I said, oh, well, I've seen, I don't read Stephen King, but I've seen that movie Misery. Have you read that book? And he just stops cold, fixes a gaze in his eyes, and says, I was on page 251 when I killed my wife. And then he started to tell me for the next 10 minutes how he was the James Caan character in the movie, who was completely captured and controlled by his wife. And he had no other choice or solution to get his freedom but to do that. He felt dynamically the same as that character. Now, obviously, he wasn't. He didn't have his legs broken. It wasn't Kathy Bates who was holding him hostage. It wasn't that situation. But psychologically, it sure was to him. Nobody had ever gotten a clue before of why he did it. Asking him, why'd you do this, doesn't do it. The psych reports didn't give us anything. That silly question, what are you doing here all day, is what got us there. So that's why I'm encouraging you to ask what you're curious about. Ask things that don't have to do with the case. I'm going to skip a couple things. We're going to go down back. Yeah, we'll skip that. We're going to go back. Oh, wait, I'm sorry. One more. You got to, with your clients, as Molly Ivins says, dance with the one who brung you. Remember who you're dealing with. This is a quote from a prison spokesperson here in the lovely state of Georgia. We are just mystified as to why he, an inmate, did what he did, killed a kitchen worker. He never gave us a clue that he was this type of violent person. Based on his record, he's had some alcohol offenses, but no other offenses aside from the beating death of his wife.
Nice.
I don't know if that speaks so much about the feeling of women or what it means to beat your wife to death, but I think we're like this sometimes. We get so offended when our clients who may have done some pretty outrageous things are outrageous with us just because we're on their team. How could he act that way to me? I was really amused when, as Daryl mentioned, I worked with Eric Rudolph, who's being sentenced probably as we speak for the Birmingham bombing, but when he pled guilty, and he went into court to plead guilty, and then news commentators, arrogant and defiant, like, he's a freaking bomber. What did you expect him to be? Demure, and, he's there saying, I did this. What characteristics are you expecting to see? I like Eric. I'm not speaking it, but that's who he is. That's what he did. So I think sometimes, I have a friend who defended a guy they resolved in a plea, another death penalty case, who pretended he was the flower delivery man. It was a murder for hire, and this woman answers the door, and he blows her away. And then after they worked out the plea, he's far away, and she said, can you believe he habeased me? I've got a remember what you're dealing with. And most of the time, it's because they are walking wounded. And just because you're on their side, they aren't always going to act like they appreciate it. And you know what? It's not personal. It's just not personal. Okay. We connected with our clients. We are back. We followed Lori's suggestions. We have our theory of the case. We're back in the courtroom. Go to the next quote. We're almost done with overheads. What should we make? Oh, next one. Sorry. This is from the British barrister Edward Marshall Hall. My profession and that of an actor are somewhat akin, except that I have no scenes to help me and no words are written for me to say. There is no backcloth to increase the illusion. There is no curtain. But out of the vivid, living dream of somebody else's life, I have to create an atmosphere. And that is advocacy. Let's talk a little bit about the atmosphere. A courtroom like this, we talk about humanizing our clients. I think we need to think about humanizing the courtroom. I mean, look at how unnatural this is. Two people are facing off at a table. Somebody's sitting up there higher than anybody else in a row. The witnesses are in a box. The jury's in a box. I mean, it's just unnatural. I understand some of you practice in federal court or in some more across the state jurisdictions where you can't move around. Figure out what you can do. Okay? Just figure out what you can do. If you have a podium rule and you've got to tag it, you can still move a lot while holding on to the podium. And you can ask questions that elicit answers that the witness has to say he's lying from one side of the courtroom, and you can talk about the statement that was, the podium, one side of the statement that was the truth from the other side of the podium. So when you move to one side of the podium, the jurors are like, oh, he's lying again. You can do things with that. You can find ways to get away from that podium, to give things to a witness, to go to a board, to do whatever you have to do. Use the space. It's yours to use. Go early. Sit in the jury box. See what things look like from up there. Do what you need to do to see what you can do to soften that. Analyze yourself. What do you want? What do you want the jury to know about you? Your strengths, your weaknesses, your tendencies. If you have tension, which most of us do before we stand up to talk, it's blocked energy. It's not a bad thing. If you didn't have tension, you wouldn't have energy. Figure out how to get the blocks away. Think of the tools that you have that are your body. Actors would call this your instrument. Think of your voice. You have a lot of choices to make. You have the pitch of your voice. You have the rhythm of your voice. You have the pace at which you speak. You have volume. And even more powerful than volume is you have whispers. Think about that. I can guarantee you I will at some point, I'm going to only be here till Wednesday, but I'll go in a room when you're doing your opening or doing your cross-exam or something that you're doing, and somebody will say they have a problem with their hands. They're just not doing the right thing with their hands. And it generally comes in two varieties. One's the fiddly. People tend to stand like this. Or guys in pockets, jingle things like this. Or some people do this. Or whatever it is, it's not your hands. It's because you're not connected with what you're doing. You've got somebody up here walking at you saying, oh, you must look stupid. You must have said that word wrong. Oh, you misspoke. And that makes us feel, tense, and so our hands get goofy. So get involved in what you're doing and what you're saying, and you will have the right gestures. Think about the words that you want to use that we've already talked about. Read from a book. The Bible is a great source, whether you happen to be religious or not. If there's a courtroom Bible that you can use, if they use a Bible to swear people in your jurisdiction, if you're allowed to use that Bible to read a story, use it. It surprises the heck out of the prosecutor and the judge for you to do that. There's a great story in the book of Daniel that's only in the Catholic version of the Bible that I've found. Susanna and the elders, extrinsic impeachment, right there in the Bible. of the rhetorical devices that you can use. I'm sure you'll hear a lot about talking about things in trilogies. People remember them. Alliterations. She was traumatized, terrified, and torn. Find those in your case. Metaphors. She was whipped with words and thrashed with humiliation. Find those in your opening statement. Analogies. Life is like
A box of chocolates.
a box of chocolates. We remember them. That's exactly right. Ask questions that you want jurors to answer. Ask those rhetorical questions where they can only come up with the answer that you have. Play with all this stuff. During the next 2 weeks, while you're here are my hopes for you. My hopes are that you will try doing the same things that you have been doing in a different way. I hope that you'll be aware that you have choices to make and that you'll make new ones. I hope that you will take risks. I hope that you will not edit yourself. I hope that you'll spend a little less time in your head and